90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Our guest tonight is attorney Dan Krimmer. He's a very experienced real estate attorney, and he also is the president of Class Abstract. That's a title company in Garden City, but they handle transactions all over the New York area. And today he's going to tell us about how to have a successful real estate transaction, whether you're the buyer or the seller. And if you're the attorney, how to do a good job for your clients. Dan, welcome back to Law You Should Know.
Thank you. Always a pleasure being with you, Ken.
At the tail end, you're always asked to resolve problems for the buyer or the seller to make that closing take place and help speed it along. So I just thought you could give some information that would help people avoid some of the problems that you see and help attorneys to resolve every day. So I leave it to you.
Absolutely. And I'll try to provide as much information in this limited amount of time. Let's start with what a seller should do in order to prepare for a transaction. They need to provide their attorney with a number of items. 1, the last deed of record, how they took title. 2, if they have a copy of their title policy, so it shows what exceptions they took subject to when they purchased. 3, if they have a survey, the survey should be certified to them, to the lender if they took out a mortgage when they purchased, and also to the title company that insured them, which is the title policy that they're providing. The description of the premises, which would be on the deed. If for some reason they can't find the deed, either they lost it, misplaced it, never got it, they should have a copy of the description, which would be in the title policy. The last account statement for their mortgage, if they have a mortgage against the premises. Any certificate of occupancies, which I'll get into in a little while. That means that the structures are legal. Whatever permanent structure there is on the premises needs a certificate of occupancy. That could be the house, garage, a shed, depending upon how large the shed is, if it's a permanent structure. Any rooms that have been added, a Florida room, and then a copy of their taxes if they have it, so that the purchaser can get an idea of what the existing taxes of the premises are. All of that will help the seller's attorney prepare the contract of sale, which will be sent to the purchaser's attorney. Or sometimes there could be a sit-down contract where the purchasers and the sellers get together at a table and all the issues are ironed out, the negotiation takes place, and the contract signed by both parties. Before you go to contract, usually the seller gets a broker. Sometimes they can show the house on their own, but very, very rare. They usually get a broker. They can have an exclusive listing. Sometimes it could be for 3 months, 6 months. Very often, if the broker, the exclusive broker, does not sell the premises immediately, they'll put it on multiple listings. So then there'll be 2 brokers. It'll be shown by all the brokers out there, and the brokers will split the broker commission. Once they find someone who's going to purchase the premises, usually a binder is signed, and then before they go to contract, the buyer will usually have an engineer's inspection done. They have an engineer who comes in, who looks at the entire premises, goes from room to room, checks to see if there's any damage, checks to see what the condition of the premises is, usually looks at the roof, looks at the sinks. He looks to see if there's any problems, if there's any cracks in different parts of the house. Looks at the foundation, because it's extremely important that the foundation is in good condition. Checks to see what the overall condition of the premises is, and tries to give the buyer an idea of how much money they're going to have to expend once they purchase the premises, will they need extensive renovations? Is the house in move-in condition? Is there anything they should be worried about? Is there anything that looks like it was added onto the house that they should make sure that they have certificate of occupancies for that I mentioned before? So those are the preliminary things that both sides should be doing.
And what if there are special circumstances? Perhaps one owner has passed away, or if both of them have passed away. What if it's owned by a trust or some other complicated arrangement?
Okay. Those are what winds up happening in a lot of different circumstances, particularly when you're dealing with residential transactions. Let's take death first. Very exciting topic. One, if you have a husband and wife who own the premises and one of the spouses has passed away, then you have what's called the survivor, the tenant by the entirety, survivorship. That surviving tenant by the entirety owns the premises by themselves, and they can sell. If they're selling for consideration, which is usually the case, then they don't have to worry about federal estate tax, New York estate tax, judgments against the party that died, because those judgments die with them. They will have to provide a death certificate, and they'll also have to provide an affidavit that at the time of death, the other spouse that they were married to, they were married, they weren't divorced. If, let's say, they had been tenants by the entirety, but they had gotten divorced before one of the spouses died, then they would have become tenants in common. If they're tenants in common, then the spouse that died, their 50% interest in the entire premises would go to their heirs. So you would have to see if they had a will. If they had a will, it would go to whoever they would be getting under the will, and that will might have to be probated. Then we're talking about estate taxes. There could be a possibility depending upon the amount of their estate, federal and New York estate taxes that are due and owing. Also, did they die in a nursing home? If they did, there could become a Medicaid lien. So we have to look at that. We also have to make sure that there's no debt or any other expenses that are outstanding that could actually attach to their 50% interest. One other thing, their heirs, believe it or not, there's a case of record which says that upon their death, any judge, the property immediately goes to their heirs, but any judgments or liens against their heirs attach to the property. And even if that heir renounces their interest in the property, the judgment still attaches. So any judgments against their heirs would have to be paid off, and those names would have to be run as part of the title search. You talked about trusts. Trusts are very interesting and becoming very, very prevalent. There are all different kinds of trusts. First, let's talk about an revocable trust. With a revocable trust, that means that the party that created the trust generally can revoke that trust at any time. So we look to see what the last deed says. Let's say they created a trust, they took title, then they created a trust, and they conveyed the property into the trust. We then need to see a copy of the trust. What does the trust say? What powers are given to the trustees? What happens if one of the trustees dies? Are there successor trustees that are appointed? What happens if one of the trustees decides to revoke their trusteeship or they no longer want to act? Who winds up taking their place? Just the successor trustees, that are mentioned in the trust, do they take their place? Or does just the remaining trustee, if let's say there were two trustees, does the remaining trustee have the power to act? That's what the trust agreement will tell us. The other thing we have to watch out for, in the trust agreement, does the grantor of the trust, the settlor, the one who created the trust, who owned the property and put the property into the trust, do they reserve unto themselves what's called a power of appointment, which means that at any time they can exercise that power of appointment and possibly convey the premises or take the premises out of the trust and put it back into themselves or into another trust or to some other parties. So it's extremely important that we not only get a copy of the trust agreement, but we're also going to get affidavits stating that there have been no changes or amendments to the trust and that the parties that are acting and conveying title when we go to closing are the parties that are authorized to act. So those are the important things about a revocable trust. An irrevocable trust is the exact opposite of a revocable trust. It means that the party that owned the premises is giving up complete control of all of the assets that they put into the trust, and only the trustees can act. They can't take it back. They can't come back and say, okay, now I'm in control of the property. No. It means that it's irrevocable. They've given up all power. Again, we have to see if there's a power of appointment. Last thing, if you convey into a trust or you convey into some other entity, does the party who's conveying out reserve onto themselves what's called a life estate, which they are allowed to do? If they keep a life estate when the property is transferred, not only does the entity that's entitled, that the property's been conveyed to, not only do they have to convey out, but the party that retained the life estate also has to convey out their life estate.
Unless you're going to buy it and they're going to be your tenant. So the property...
No, even if they're going to be your tenant, if they're going to be your tenant, you want them out of title in any way, shape, or form, and you can give them a lease. Sometimes we have what's called a sale leaseback. The party that owns the property is conveying to another entity, and that entity leases back to them. Maybe they're doing that because they depreciated the property. They can no longer get any tax deductions or tax breaks, and so they want to rid themselves of the property, but maybe they're running a business in the premises, and they still want to be there. The way that new purchaser would wind up being in a relationship with them should be on a landlord-tenant relationship, not a life-tenant relationship.
And just going back to trust, in recent years, you said many properties, more and more properties are held in trust, and that's because?
It's because, again, something that normally the buyers and sellers attorneys don't get involved with, or even the title company. That's usually the party in title. They primarily do that for tax reasons because they want to avoid estate taxes. They want to pass their property on to their children or their heirs. Or
spend down their assets to be eligible for Medicaid.
It could be a spendthrift trust. There are all different kinds of trusts, but they want to minimize their tax liabilities.
So it's important for the lawyer, for the seller, and also for the buyer to find out how that property's being held and what's going on with it and who is the exact owner.
Absolutely, because that seller's attorney is going to have to prepare necessary documents in order to close, which is the deed and other ancillary documents, depending upon what county you're in, and it varies from county to county. The more information they have, the more that they can help. Just as an example, mortgages. If there's a mortgage on the premises, they need to know how many mortgages, what kind of mortgage, because it could be the usual mortgage, which is made to an institutional lender, any lending institution, any bank that you see on your local corner in your community. But there also could be a mortgage which is sometimes made to a private individual. A mortgage could have even been made when the purchaser bought back to the seller, which all of these mortgages are purchase money mortgages. They were taken out at the time the purchaser was purchasing the premises, and it's called a purchase money mortgage because they needed the mortgage proceeds in order to buy the premises. At time of closing, that mortgage is usually accelerated. Usually in a residential transaction, it can't be assigned, and it has to be paid off at closing. So if it's an institutional mortgage, the seller's attorney has to get what's called a payoff letter. The closer verifies what the outstanding balance of the mortgage is, calls up the lending institution. That's why they need the payoff letter. Usually the seller's attorney gets that a week or two in advance of closing. That's verified at closing. But if it's a private mortgage, usually what the title company will require is that either they get the mortgage stat in advance of closing, or the mortgagee appears at closing with the mortgage stat and the note because it's a private lender. Last very important thing, which has become a really big problem at closings, are credit line mortgages. Very often, the owner of the premises may have taken out a second mortgage on the property because they wanted to do some home renovations or they were starting a business, whatever the reason, and they took out a credit line mortgage, which means that they can take bring downs on that mortgage. They can take parts of the mortgage, even take the mortgage in total, then pay it back, and the mortgage is still open. It doesn't get satisfied. It depends upon how long that credit line mortgage lasts. But one of the things that has to happen at closing is when they come with a payoff letter for the credit line mortgage, they also have to have what's called in that payoff letter a frozen paragraph, which says that mortgage can no longer be drawn upon. That even when it's paid off, it's paid off in its entirety. There is no way that party can once again, like they may have been able to do before, draw on that mortgage. So it's very, very important because that could hold up a closing. Or what happens is the title company will very often take not only the full amount of the mortgage and the payoff, but an additional 20% over what the original mortgage amount was to make sure that if it's not frozen and if that seller was to draw on the mortgage, they would have enough money to still pay off whatever was taken. Okay,
we're going to continue our discussion in a moment. I want to remind our listeners that you're listening to Law You Should Know here on WHPC 90.3, the voice of Nassau Community College. If you've missed any part of this program or you want to tell someone else about it, you can find the podcast at nccradio.org, and there's no charge to it. If you wanted to go back and listen more closely to any of the points that Dan has mentioned, just go back to the podcast at nccradio.org. And, of course, you've been listening to our guest, Dan Krimmer. He's the president of Class Abstract with offices right here in Garden City, and they handle title searches and provide title insurance for residential, commercial buildings all over the New York area. Dan, let's just take a minute to talk about what you're doing and your role as the title insurance company and conducting the title search to make all this happen.
One of the things I'm not doing is sleeping. That I can tell you. Transactions have become...
And you may be losing sleep.
Absolutely. And years of...
But you are doing important work, and without your work, the transaction cannot take place because
Correct.
You mentioned all the things going on with the seller, and you're sort of coming in on behalf of the buyer, and you have to make sure they're getting a proper title.
Correct. I have to make sure that all the exceptions are cleared, that the buyer is taking subject to a title that's not only insurable, but hopefully marketable. I mean, there are a gazillion issues which we could go into. For instance, there are covenants and restrictions against properties. That are things that you can't do that may have been placed against the premises, such as setbacks, where you're not allowed to build within a certain amount of frontage, certain amount of on the sidelines. You can't build that close to where the property, borders, not only on the street, but on your existing neighbors. There are certain covenants and restrictions that prohibit certain sizes of houses that could be built, fences that can be put on. Also, there are what's called easements. If you don't have electric, gas, telephone, your property is worthless. So there are those kind of easements to the electric company, to the gas company, to the telephone company. There are certain parts of the premises that you can't build on. Usually, anywhere between 2 to 5 feet of the boundary lines that you can't build structures on, because utilities have to be able to get on and off those portions of the premises. Sometimes you need driveway easements, particularly in the city. There are reciprocal driveway easements where there's not enough room on your premises.
There's a shared driveway.
For a car to get in. Correct. It may affect 3 feet of your property and 3 feet of the property next to you.
But if you're buying something, you want to make sure you have that right.
You want to make sure that you're able to go over that portion of your neighbor's property, and you also want to know what your property is subject to.
And you also want to understand your responsibilities for maintaining or repairing that property.
Absolutely correct. Sometimes, particularly in Nassau County and even in, certain areas of Suffolk County, in very, very exclusive neighborhoods, streets haven't been dedicated to the public utilities. And so if you have a private street, if there are repairs that have to be made, it's a really bad winter and there are potholes, everybody on the block that borders on that private street has to chip in to make the repairs. You have to chip in for snow removal. You have to chip in for sanitation, for garbage removal.
And you also want, if you're buying a unique property, you want to make sure you're entitled to beach access or access to shortcuts, whatever you think you're getting.
Beach rights is a very, very interesting topic, which we could talk about for 6 hours. But beach rights are very, very exclusive and very, very prominent properties. And what it means is you're able to walk over a certain amount of area to get to a private beach. It's not open to the public community. And this little community, this association, all of the houses there have beach rights. So where questions come up is if a property is subdivided and a new house is built, does that new house have easement rights to the beach? Because prior to that house being built, it didn't have any easement rights. Right. So there, you really have to look at what has been granted, when were the easements created. Also, when I talked about covenants and restrictions before, there's 2-acre zoning in certain parts of Nassau and Suffolk where there has to be at least 2 acres. So if you transferred a portion of your property to somebody else and it's no longer 2 acres, you may not be able to build further on to your premises. And especially in exclusive neighborhoods where they want to build up or they want to build out, you may not be able to do that. You may not be able to add that swimming pool that you wanted to add.
You mentioned before that the circumstances where one spouse dies and how the house would be conveyed. What if both parents have passed away and there are one or more children, but they've never bothered to change the deed officially, and maybe they're still living in the house? So what happens then?
Okay, so in that case, it depends upon whether or not they have wills and whether the wills have to be probated. The first spouse that died, we don't necessarily have to worry about as much because chances are the second spouse got the marital exclusion and probably there's no federal or New York state tax due and owing against that spouse. But the second spouse that died, there is no question that there may be federal and New York estate tax, again, depending upon where the house is, how large the estate is. So there's that issue. There's also the issue of probate. And letters of testamentary usually are good for 6 months, whether or not they have to be renewed. Are you selling the house immediately? Not selling the house immediately.
And would the children have the right to sell it through, because if they can prove they're the children?
The children that are heirs under the will. I've seen wills where, so this is boys and girls listening out there, be good and be nice to your parents. If you're not, I've seen wills where children have been disowned.
And even adult children should be nice to their parents.
Everybody should be nice to their parents.
And what if there's no will?
Especially this parent.
What if there's no will?
If there's no will, then what happens is you have an administration. And that's also a probate. And somebody applies. Usually one of the heirs, usually one of the children, or maybe even more than one of the children.
And that would be required to sell the property?
Yes. Yes.
And this is something the attorney for the seller would have to do. But go ahead.
Or an estate attorney in conjunction with the attorney for the seller. Sometimes in order to save the party's money, if it's clear how many heirs there are, and if you get affidavits of heirship, and if you get the death certificates, sometimes the title company will not require you to do a probate. And they'll take all the affidavits of heirship, all the death certificates, all of the proofs that you provide, and to save them money and to expedite the closing, they may not require a probate. It's on a case-by-case basis.
And they're going to scrutinize it all closely.
Oh, absolutely, because nobody wants somebody appearing later on and saying, I have an interest in the premises. Hi, I'm home.
Right, because you want to make sure the seller has the right to sell it.
That the seller not only has the right to sell it,
and is only selling it once,
and that they are the proper owner of the premises. Correct. We have to make sure in this day and age there are forgeries. I'll tell you one very fast story. I had a situation. Husband and wife are at a closing. The closer calls me up. He says, I just want you to know that 2 minutes ago, the wife of the husband called up and said. She left a message. She wants the husband to bring home a dozen eggs and a quart of milk. And she said, what should I do? Because the husband's here with the person that he's saying is the wife. What should I do? So I said, what you should do is leave. You buy a quart of eggs, a quart of milk and a dozen eggs, okay? Do not close.
And throw it at that other person.
Obviously, they're trying to perpetrate a fraud, and I don't want to have to track down the husband in Brazil.
I just want to remind our listeners, you're listening to 90.3 WHPC, the voice of Nassau Community College in Garden City, Long Island. Our guest is Dan Krimmer. He's the president of Class Abstract. He's also a very experienced real estate attorney, and he's talking to us about what's involved in a real estate transaction, and especially what information the buyer or seller has to give their attorney, and their attorney has to give the title company.
So let me tell you, let me just elaborate.
We just have 1 or 2 moments, so just take
one or two moments. I need 12 or 14.
Go through your tips.
There are different types of way to take title. If you're a husband and wife, tenants by the entirety. If for some reason you don't want to take as tenants by the entirety, you have to specifically say in the deed that you're tenants in common. If you're not married, you can take title as tenants in common, or you could take as joint tenants with the right of survivorship, which means that if one of you dies, the survivor gets the entire premises. It depends upon whether you think you're going to get married, whether you're going to stay together. If you have heirs that you want to take title or to get your percentage interest in the premises, then you want to take as tenants in common. You don't have to take 50-50. You can take title in different fractional interests, depending upon how much money one side puts in, who's taking out, the mortgage, how much you're going to guarantee, who's going to pay what. So that's extremely important. As far as mortgages go, you can apply to a lending institution. You can apply to a mortgage company. I recommend these days if you can afford a 15-year mortgage, rates are at all-time low. Right now, you can actually get a 15-year mortgage for 3%, which is outrageous, probably the lowest rates in history.
And these are things the attorney should find out from the buyer and convey to the seller is what are the buyer's plans for financing the property?
Well, both parties. Last thing that I really didn't have much time is certificate of occupancy, which is extremely important, which means that all the structures on the premises are legal. If you put in an illegal apartment can be legal if it's a mother-daughter, meaning that your mother actually lives in that apartment or a relative. You usually have to renew that every year. It's a permit. But if they're no longer living there and you're renting out to a tenant, that is really an illegal apartment.
So I just want to remind our listeners on that issue, the attorneys have to closely ask the sellers, and the sellers have to be honest with their attorneys about what they've done. The buyers have to educate their attorneys as to what types of items they've seen that may create problems.
Right, what they're willing to take subject to. Sometimes I have transactions where a buyer will take a house that's totally run down and needs to be renovated because they're getting a great deal. So, yes, both clients, the buyer and the seller, have to advise their attorneys exactly what they're looking for, what they've agreed to, because every transaction is different.
I just want to remind the listeners, you've heard a lot of information from Dan Krimmer, the counsel and president of Class Abstract right here in Garden City. Attorneys can always contact them for further information. And also you can listen to the podcast at nccradio.org to just review or tell a friend about all this information. But remember, it's information only. You should get legal advice from your own attorney. Please tune in next week at this same time to another program on Law You Should Know on 90.3 WHBC in Garden City, New York, the voice of Nassau Community College.